It may surprise you to learn the United States is not a pure democracy. The framers of the U.S. Constitution chose not to create a democracy. Instead, they established a republic. Democracy is a form of direct popular government. The people vote and accordingly directly decide issues. A republic, in contrast, is a form of government as originated in ancient Rome, in which the people elect representatives who make the laws for the people. To most of the framers, indirect lawmaking through representatives was preferable to direct popular lawmaking. Democratic and Republican forms of government share an important feature. The authority to govern rests in the hands of the governed, not in the hands of the governors. The two differ in how that authority is exercised. In a democracy, it's exercised through direct popular vote. In a republic, the people's sovereignty is exercised through their elected representatives. In a republic, accountability of those who govern is checked in several ways, but the most significant is by periodic election. Today, the United States can best be characterized as a democratic republic or a constitutional republic because most laws are made through elected representatives, but popular referenda are also used to make law in many jurisdictions. In addition, many jurisdictions provide for direct recall of elected representatives by the people, and there's a growing movement of deliberative democracy. In deliberative democracy, the role of the people transcends voting in law, and government decision-making is viewed as a community, not solely as a legislative process. Today, the descriptors democracy or constitutional republic refer to more than one source of lawmaking. They also express the idea that governmental authority, as well as the will of the popular majority, should be limited by fundamental civil liberties, and the government officers are accountable for their actions. In the context of administrative law, we assume that keeping administrative officers who are not elected and who rarely engage citizens in decision-making accountable is a generally accepted ideal. Congress and the president are accountable through the ballot box. Federal judges are less accountable, as intended by the framers of the Constitution. Agency officials, however, come to office through an appointment process, and in some instances, they're not directly accountable to the people who appointed them, for example, the President and Congress after they are appointed. Furthermore, the authority of the President or Congress to remove some administrative officials is limited. Accordingly, much of administrative law is concerned with how to keep the bureaucracy accountable in our democratic republic. As you proceed through this course, consider how the subject you're discussing relates to keeping agencies from becoming too independent, arbitrary, or a threat to freedom. The word democracy has become a popular way of referring to accountability in government. The Constitution establishes a federal form of government, the federal, national government, and the governments of states. This horizontal division of authority is known as federalism. The powers of the federal government are spelled out in the Constitution, but the powers of the states are not. On the surface, the 10th Amendment appears to establish two discrete zones of authority and one zone of rights. Beginning with the latter, the amendment protects individuals from both state and federal authority in some circumstances. This is also accomplished by the many rights explicitly protected by the Constitution and its amendments. As to the relationship of the states to the federal government, the Constitution is not clear. Two primary theories about the relationship of federal and state authority have been asserted to define the federal-state relationship. The first is dual federalism, the federal system of government where both federal and state governments are sovereign with different and occasionally concurrent jurisdiction. The second theory is hierarchical federalism. This approach positions the federal government as supreme, with the states possessing only residual powers not possessed by the federal government. As the authority of the federal government expands or contracts, the authority of the state changes in the opposite direction. Because the federal government and state governments often regulate different areas, each must establish its own agencies to administer and enforce their own laws and policy. Accordingly, there are a multitude of agencies, each with its own popular rules and procedures. In addition to federal and state agencies, many local governments have their own agencies. Finally, note that although the dual and hierarchical federalism models provide a framework for understanding the authority relationship, the federal and state governments often cooperate. This form of partnership is commonly known as cooperative federalism. Cooperative federalism, as a descriptor, is not a structural or legal model. It is instead a relational model. A horizontal division of power, known as a separation of power, also exists. The doctrine of separation of power divides the powers of a government into three branches: executive, legislative, and judicial. At the national level, the executive branch consists of a president of the United States, the president's subordinates, and agencies. At the state level, it's comprised of a state governor and his or her subordinates and state agencies. The executive branch of government is responsible for administering and enforcing the laws of government. The legislative branch is represented by the Congress of the United States at the national level and the various state legislatures at the state level. The legislative branch is responsible for the creation of law. A written law enacted by a legislative body is also called a statute. The judicial branch is represented at the federal level by various federal courts, with the Supreme Court of the United States as the highest court. Each state also has its own court system. The judicial branch is responsible for administering justice, resolving disputes, and interpreting the law. The framers intended for courts to be free from political pressure, conventional wisdom, and the waves of popular opinion. Normally, one governmental branch may not exercise the responsibility of another, even if the two branches agree that one is to delegate a particular function to the other. This maintains a balance of power. The branches also check one another. That is, rarely does the Constitution establish a procedure whereby a branch may exercise its authority without being reviewed or authorized by another branch. The framers of the Constitution of the United States embodied these principles into the Constitution. The purpose of the doctrines of federalism and the separations of power is to prevent the centralization of power. This checks and balances system protects civil liberties. The concept of separations of power is important to administrative law. Generally, the Constitution does not address federal agencies. It creates the three branches of government, and all three branches of government are involved with agencies. All three also play a role in checking agency behavior. The term bureaucracy is loaded. That is, many people have preconceived notions about the meaning of the term, and often those ideas aren't positive. For our purposes, bureaucracy is used to describe the management of the United States, the states, and local government. These include the executive leaders, executive agencies, and other agencies of all of these forms of government, including a few private agencies that provide public service. Under the system of separations of power, Congress creates, defines, and funds agencies. The president, in contrast, is the national government's chief executive officer. As such, the president is the highest officer responsible for enforcing and administering the law. Presidents exercise control over agencies. First, the president is the direct head of executive agencies. As such, the president has considerable authority in the operation of those agencies. Second, the president can recommend to Congress agency reorganizations and amendments to enabling law. Third, the president has some authority to establish policy. This is done through executive order. Fourth, the president plays a role in the appointment of agency heads. Executive agency heads, such as the Attorney General and the Secretary of Commerce, fall directly into the presidential chain of command. In many respects, of the three constitutional branches of government, Congress possesses the greatest ability to control the federal bureaucracy. Courts also play a role in controlling agencies. Courts interpret Congress's mandate in judicial delegations to agencies and review agency adjudication and rules.